Good afternoon, everyone, and welcome to the webinar, Advancing Justice with Forensic Genetic Genealogy. Today's program is presented by Equitas and SAKI, the Sexual Assault Kit Initiative. This webinar will be presented by RTI's Ashley Rodriguez and Equitas's Patty Powers. My name is C. Ross. I am an Administrative Associate at Equitas, and I'll be moderating today's webinar. If you have a question during the presentation, please enter it in the question and answer box. We will answer questions periodically throughout the webinar. You are also welcome to contact us directly at any time following today's webinar, and we will send you contact information during our follow-up. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. As national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website, equitasresource.org. Next slide, please. Today's webinar is supported by the U.S. Department of Justice Bureau of Justice Assistance. The information presented in this webinar does not necessarily reflect the views of the Department of Justice. And now I will hand it over to our presenters.
Hi, everyone. My name is Ashley Rodriguez. I am a program manager in the Center for Forensic Science and Advancement and Application at RTI International. In addition to wearing my management hat, I also work on two very large BJA-funded training and technical assistance projects. I am the co-project director for the Forensics Training and Technical Assistance Program that supports recipients of federal funding under BJA's forensics portfolio or their forensics programs. And that includes programs such as prosecuting cold cases using DNA, the Missing and Unidentified Human Remains Program, strengthening the Medical Examiner and Coroner Program, and so on. I am also the TTA director for the Sexual Assault Kit Initiative, and we support grantees throughout the country who are seeking to enhance their response to sexual assault and other violent cold case crimes. And just as a side note related to SAKI is that SAKI was the first federal program to actually allow federal funds to be used in support of genealogy. So we have grantees, we have many grantees who are actually performing this work right now. And just very quickly, prior to coming to RTI, I spent about 13 years working at the National Center for Missing and Exploited Children, providing training and technical assistance to law enforcement and medical examiners throughout the country who were dealing with cases involving unidentified deceased children. And it was there that I first became aware of and involved with forensic genetic genealogy, as we were actually using the technique to identify these unknown children even prior to the arrest of the Golden State Killer, which occurred in 2018. And we'll talk about a little bit in just a few minutes. But ever since then, I have spent a lot of time educating law enforcement on the technique and how to effectively apply it to their criminal investigations. And I'm really excited to be here. And I just wanted to say thank you to John Wilkinson, to Equitas, and to IPS for allowing me to speak. And I will turn it over to my co-presenter, Patty Powers, to introduce herself.
Thank you so much, Ashley, and thank you very much, C. Thank you, everybody, for being here. We know how busy it is and really appreciate your carving out some time to be with us today as we discuss forensic genetic genealogy. I'm Patty Powers. I'm a senior attorney advisor with Equitas. Before I joined my colleagues at Equitas, I was a senior deputy prosecuting attorney in Washington State for 27 years. I supervised our sexual assault and domestic violence unit, and in that process spent most of my time in trial. And my specialty in litigation were cases of sexual assault, both child sexual assault as well as adult sexual assault, intimate partner violence, crimes against children, sexual exploitation, and homicides, specifically those involving intimate partner violence, crimes against children, or sexual violence. And I tried both cold and current cases of homicides. I had the opportunity to work very closely with forensic experts from DNA, from crime scene analytics, from bloodstain pattern analysis, from ballistics, from fingerprint analysis, and really learned the value of this consultation as well as the importance of forensic expert testimony. Forensic expert testimony really gives us an opportunity to focus on forensic evidence of the victim's experience of the crime and to offer that very important corroboration. While I was still a prosecutor, I was appointed as an HQE for the United States Army in the Investigative Division. In that capacity, I was able to consult on sexual assault and domestic violence cases, as well as provide training at Fort Leonard Wood, as well as in Germany. And I want to note, I did that on an intermittent basis because I was still very much a prosecutor, spending most of my time in trial, but was able to take vacation time to do this other important work, which I really did enjoy. I was also a member of a sexual assault response team providing training in sexual assault response throughout the United States as well as in Japan. It's great to be with you today, and it really is always a pleasure to work with Ashley.
Thank you, Patty. You as well. So we do have a lot to cover today. So we're going to quickly go through some of the objectives. I'm going to talk about the first half, which will be focused on really getting an understanding of what genealogy is and how it can be applied to criminal investigations. And then Patty is going to jump in with a couple of the objectives that we will be looking at to wrap up today's webinar. So first and foremost, in my portion of the presentation, we're going to be talking about what exactly genealogy is, or FGG is, and talking about how it can be applied to different types of cold case investigations. We're going to look at how genealogy differs from familial DNA searching, which is something that I commonly see mixed up and used interchangeably. We're going to be talking about some of the limitations of the technique. So it is something that is flashy and it's in the media and it's resolving a lot of cases, but it certainly does still have limitations that we need to understand in order to most efficiently apply this technique. And lastly, we are going to be talking about the actual goal of genealogy. What do you get from this type of investigation, and the importance of confirmation DNA testing towards the end of the investigation. And Patty, after we understand what genealogy is, this is when Patty's going to come in and talk about a lot of considerations from the legal side.
Yes, and we're going to focus on how we go about identifying cases that might benefit from forensic genetic genealogy. At the core of that discussion, really at the heart of that discussion, is going to be the importance of collaboration, talking it up with other professionals, learning from their expertise. Then we're going to develop a conversation into the areas of current issues that prosecutors and investigators in the field are seeing with forensic genetic genealogy. We're going to explore issues with forensic genetic genealogy investigative leads and how we can refer to that in a search warrant, in an affidavit for a search warrant. How is that going to look in pretrial litigation? Is there going to be trial testimony in that regard? Another very important aspect of our discussion is going to be issues that may impact the seizure of abandoned DNA. And we're going to explore a number of different cases in that area as well.
All right. So as I briefly mentioned earlier, I'm sure a lot of you are familiar with the Golden State Killer and how genealogy led to his arrest back in 2018. It was at that time that genealogy kind of exploded within the media and really came to the forefront of the criminal justice field. So since that time, genealogy really honestly has been a game changer for law enforcement. It has provided a brand new outlook, honestly, on cold case investigations. Cases that we once thought that were unsolvable, we now have a much more positive outlook. And if you do just any type of Google search related to genealogy, you are going to find tons of headlines, and news articles about victims who have received justice through the application of this technique. And these are just some. These are a little bit older, but definitely today, if you were to do the same type of search, you would still be seeing a lot of news articles, and probably even more than what I found when I was doing when I was preparing this presentation. So what exactly is forensic genetic genealogy? Genealogy is defined in the dictionary as the study of family ancestral lines. So in practice, genealogists are using things like historical records, oral histories, genetic data, and other types of resources to trace a family lineage. Forensic genetic genealogy is law enforcement's use of DNA analysis combined with traditional genealogy research to generate investigative leads for unsolved violent crimes. So in other words, we are using this same type of traditional genealogy methods, and we're combining that with DNA from potential relatives, and we're using all of this to generate investigative leads that will help law enforcement identify unknown perpetrators or unidentified victims. In 2019, the U.S. Department of Justice did issue this interim policy on forensic genetic genealogy. This policy was issued as a way to promote best practices and to talk about the most efficient ways to apply this technique to criminal investigations. If you are currently doing genealogy work within your agency, or if you are thinking about doing genealogy and you're not familiar with this policy, I strongly encourage you to Google the interim policy. I have the link there, but I recognize you can't necessarily click on it. But Google the policy and read it. It is fairly lengthy, but there is a lot of good information in there, not only on what genealogy is, but and how it works, but also just on, again, the best practices and the most effective way to apply this technique to criminal investigations and to ensure that we are actually preserving this technique for the long term. Within the interim policy, it does talk about the types of cases that genealogy should be applied to, and it defines, or it states that we must apply this to violent crimes. And when we say violent crimes, we're referring to homicide, sexual assaults, unidentified human remains cases, or missing persons cases. There is also language in the interim policy that says that it can be authorized for other types of violent crimes when there is a substantial or ongoing threat to public safety or national security. If you don't remember anything else that I say today, please remember this slide, and remember that the goal of genealogy is to provide investigative leads that will ultimately assist law enforcement in identifying an unknown perpetrator or a victim. It's very common to hear that, you know, an identification was made from genealogy, or genealogy identified a perpetrator. And while, I mean, that's kind of accepted language, and it is somewhat true, but the core of it is that genealogy doesn't really identify perpetrators. It doesn't identify victims. It identifies the leads that leads to those identifications. Okay, and we're going to continue talking about that a little bit more. But the way that I think about this is that a genealogist handing you the name of a potential suspect is no different than someone calling into a tip line and saying, "I believe that Joe is the suspect in your case." Law enforcement would be following up on that lead, trying to determine whether or not Joe was a good fit for their case, right? They'd be trying to determine if Joe fit within the context of the crime. And this is the same thing. Law enforcement has provided a lead that stemmed from the genealogy work, and it is up to law enforcement to then conduct the traditional police work that is needed to determine if the information actually makes sense within the circumstances of their case. And if so, if they feel that it is a viable lead, then to move forward and actually confirm it through more traditional DNA analysis. This is just a high-level overview of kind of how the process works. We are going to be talking about some of these steps a little more in depth. But in general, the process begins by submitting DNA evidence from an unknown perpetrator or a victim to a laboratory that can generate a data file that's compatible with the direct-to-consumer or third-party genealogy databases. And once that data has been uploaded into the databases, it is then matched to profiles from the public consumers, and the matches are made based on familial relatedness. So in other words, it's how closely the two individuals are related. The family trees of these matches are then researched and built out in an effort to really figure out how the suspect or the victim may be related to the matches that you were seeing. And if we're lucky, we may be able to narrow in on one individual or a couple individuals, and these are turned over as investigative leads to law enforcement, who will then follow up, see if everything makes sense, and then the very last step is that confirmatory DNA analysis. And this is done through direct comparison through the STR testing that a lot of you are probably familiar with. And this is the step, this confirmatory DNA analysis is the step that leads to your probable cause for an arrest or the justification to close a case, potentially by exceptional means if, you know, the potential suspect is deceased, and even to give a death notification to a family if we are considering an unidentified victim. The confirmatory DNA analysis is that step that kind of opens the door to all of those types of things. All right, the case submission criteria. What kind of cases can we actually submit for genealogy? This information is from that interim policy. Again, I'll be citing that policy several times throughout the presentation. We already talked about the first one, that cases need to be an unsolved violent crime, and primarily we're looking at homicides and sex crimes. Law enforcement does need to believe that the forensic sample being submitted was likely deposited by the perpetrator of the crime, or it's from an unknown victim. This seems pretty straightforward, but just keep in mind that, you know, we do have scenarios. I have worked with law enforcement who they have an unknown sample that was identified at a crime scene, and when asked about this particular criteria, they can't tell me that, yes, we do believe that this sample was deposited by the perpetrator. They know it was deposited by someone who was at that scene, maybe a witness to the crime or something similar, but they can't really say that it was the suspect. And so those are the types of samples that we want. We need to know that there is a reasonable expectation that the DNA that we are submitting did come from the perpetrator of the crime. That third bullet is extremely important. We need to have an STR profile already derived and uploaded into CODIS from that crime scene sample. We will talk about where this comes into play a little bit later, but first and foremost, if you have a crime scene sample and you develop your STR profile and you get it into CODIS, you know, that is the first step. We're hoping to identify the offender by those methods, but if that fails, then FGG does offer a further step, another alternative. The case does need to be entered into VICAP and NamUs when applicable, and then all investigative leads should have been exhausted. The other piece that is not on here, and I know Patty is going to talk about it a little bit more later, is just prosecutor concurrence. When you are considering submitting a case for genealogy, it is critical to have a prosecutor pulled in from the very beginning. Not only does the prosecutor need to understand the process of genealogy and kind of how you are getting from A to Z, but the prosecutor also needs to understand why FGG is the next logical step and should be able to weigh in on that decision. Prosecutor concurrence is something that is talked about in the interim policy and further elaborated on. And as I stated, I know Patty is gonna brief on that in a few minutes. Once we know that the case itself actually meets the criteria for genealogy, then we need to look at the actual evidence that we have to submit. There are several considerations when we're looking at our sample to know whether or not we're going to be successful. We're going to get a DNA profile that will work. And these three things, the quantity, quality, and the whether or not the sample is a mixture, are three things that the labs are going to want to know about. The quantity, very straightforward. How much human DNA is available? You may hear this described as, or it's measured in picograms, nanograms. You may hear that. For the quality, you know, looking at how degraded or contaminated the sample is. You may hear the lab talk about something called a degradation index. This is just a way to evaluate how degraded the sample is, the quality of the sample, and it can help inform, whether or not we are going to be successful with future testing. Quantity and quality used to be very important when we were considering submitting a case for genealogy. Back in 2018, when we were talking about submitting a case, we needed a lot of DNA, and we needed very high quality DNA. Since that time, the laboratories have advanced so much with this technique that quantity and quality don't really have too much of a role when we're considering whether or not we can submit a case. Where this comes into play is that, as you'll see in a few minutes, there are different ways that we can go about developing a DNA profile for genealogy. And that's primarily where the quantity and quality come into play. It's going to influence how a lab is going to approach your sample and kind of the path forward that they are going to take. What is still kind of throwing a wrench in things for labs is our mixed samples. So if we have a DNA sample that contains DNA from more than one person, this is something that labs are still struggling with. They have made tremendous advances in being able to parse out the mixtures or parse out all the DNA profiles from the sample and to move forward with genealogy. And I do fully think that probably in the very near future, we will be talking about mixtures the same way that I just spoke of quantity and quality, that it won't be as big of an issue or as big of a consideration. But for now, for the time being, just please be aware that if you do have a sample that is a mixture, that it may require some extra conversations with your lab before submitting the case for forensic genetic genealogy. All right, very quickly, I did want to touch on CODIS/STR profiles and how that compares to what we're talking about today in forensic genetic genealogy. So most of you are likely familiar with the STR profiles. You identify a sample at a crime scene, it is submitted to the lab, an STR profile is developed and uploaded into CODIS. And if we're lucky, that STR profile is going to hit to an offender, to the suspect in your case, right? The STR profile that is developed for CODIS cannot be used for forensic genetic genealogy. For FGG, we are using a completely different type of technology to develop what is called a SNP profile, an SNP, which stands for single nucleotide polymorphism. So obviously SNP is so much easier to say, but we're looking to develop a SNP profile as opposed to an STR. The easiest way to talk about the difference between the two profiles is that a SNP profile is much more robust. It's giving us a lot more information. So for an STR profile, where we are looking to identify information at approximately 20 locations on the genome, with a SNP profile, it can be we could be looking at as many locations as 600,000. So it's a more robust profile. It gives us more information. And when we're talking about developing a SNP profile, this is what I was saying, where quantity and quality can kind of come into play. There are different ways to go about developing it. You may hear labs talk about being able to conduct a SNP microarray, or they may do, or they may offer targeted SNPs, or they may offer something called whole genome sequencing. These are just different techniques employed to develop a SNP profile, and they all have kind of different criteria. So as an example, if we have a sample that has a tiny amount of DNA, and we know that DNA is also degraded, we would definitely want to go with whole genome sequencing. We would have our best shot using that method. Whereas if we had a sample that had a lot of DNA and it was intact, it was good, it wasn't degraded, SNP microarray might be our best option. So that is what I was saying, that we still want to know about those things to help inform how a laboratory may move forward with developing the profile. For the STR profiles that you are all familiar with, you know that local, state, federal crime labs are capable of developing these profiles and getting them into CODIS. For forensic genetic genealogy, as of right now, it is not very common for local or state labs to conduct SNP analysis in-house. And as such, there are a lot of private DNA vendors that are doing the SNP analysis for forensic genetic genealogy. I do think that that landscape is starting to shift a little bit, and I do think that in the very near future, we will see more local and state crime labs being able to bring the SNP technology online. But for right now, for the most part, the DNA work is being conducted by private laboratory vendors. All right, and I did want to take just a couple minutes before we get into really how the genealogy works to talk about the difference between genealogy and familial DNA searching. As I mentioned when we first started talking about the objectives, familial DNA searching and genealogy are not the same. However, these two terms get used interchangeably and confused all the time. So for familial DNA searching, this is the definition by the FBI, so an intentional or deliberate search of the database conducted after a routine search for the purpose of potentially identifying close biological relatives of the unknown forensic sample. So the two searches are very similar, but the way that you can differentiate or you can think about them is that when we're talking about familial DNA searching, when you upload your STR profile into CODIS, you are looking for a one-to-one match, right? You're hoping you're going to hit to your offender. With the familial DNA search, think about it as tweaking that algorithm a little bit. So instead of looking for a one-to-one match, we are now looking for a close relative of the offender within the CODIS database. So maybe our suspect has never been arrested before, they haven't provided their DNA, they're not entered into CODIS, but maybe their brother is, or maybe their father is. So that would be the familial DNA search. And so on the surface, let's see, these look, there we go. My animation was a little slow. On the surface, these look very similar. They are both advanced DNA searching methodologies that use DNA from biological relatives to develop leads to aid in resolving cold case violent crimes. However, they are very different types of searches. So for genealogy, we're talking about using SNPs. We just went over that. For familial DNA, we are using those same STR profiles that have been developed from the crime scene samples. And then further downstream, we are using YSTRs to help confirm any potential matches that we may come across. For genealogy, we talked about the need to use private laboratories, familial DNA searches, local state forensic laboratories are capable of developing the information that we need, and that's also where the searches are run. It's at the crime lab. I will say that if you would notice, I only have local and state labs. There's no federal lab there. Familial DNA searches are only done at the state and local level. We cannot do these types of searches at a national level. And that is because the CODIS database is used to conduct the searches. And as of right now, it is not allowed by the FBI does not allow a familial DNA search at that INDIS level, at the national level. So again, only state and local. Talking about the databases where these searches are conducted, CODIS for familial, again, private genealogy databases for FGG. For genealogy, this gives us the opportunity to identify close and distant relatives. With familial DNA searching, we can really only identify close relatives. We're looking at siblings, parent-child relationships. We are not able to identify, third cousins with a familial DNA search. Okay. So now moving on to actually how the genealogy stuff works. Once we get our SNP profile, it has to be uploaded into a genealogy database. So I'm sure all of you have seen the commercials of the large companies that are advertising their genealogy kits. You order the kit, you spit in a tube, you send it back, and then they're able to tell you and provide you with information about your heritage, right? So of those big name companies, the Family Tree DNA is the only company currently that allows forensic uploads. And in fact, the other big name companies do explicitly prohibit law enforcement's use of their databases within their terms of service, privacy statements, etc. So Family Tree DNA is the one that law enforcement is using most often. GenMatch Pro, you may have heard about GenMatch. GenMatch was developed after realizing that those large, the big companies, they don't talk to each other. So let's just say I tested with Ancestry.com, my sister tests with Family Tree DNA. We would never match together. So GenMatch was created that would allow users of the big name companies to be able to download their data and upload it into this database. And so it's kind of a hodgepodge of data from all the big name companies, and it allows then to be searched. So in the scenario I just provided, if my sister and I both downloaded and uploaded into GenMatch, that is where we would see the match, even though we initially tested with different companies. GenMatch does not contain profiles. Every profile that has ever been entered into any of the big name companies, it is only populated with profiles and information from individuals who have proactively gone in, downloaded their own data, and uploaded it into GenMatch. Both Family Tree DNA and GenMatch Pro, they do have fees for uploads for forensic samples. And they both have policies in place that allow their consumers to opt in to law enforcement searches. So basically what that means is that when I sign up for Family Tree DNA as an example, it's going to ask me if I want my data searched against forensic samples, and I either opt in or I opt out. If I opt out, law enforcement will never see my information, even if I, as an example, am a sibling, a full sibling of their suspect, right? Opting out, law enforcement doesn't have access to the information, okay? That last database listed on there, DNA Solves, this is a database that primarily focuses on unidentified human remains, but I did want to throw it up there since genealogy has played a huge role in identifying a lot of unknown victims. All right, so once we upload into the databases, you're going to get a list of matches. And matches are consenting consumers, so people who have paid, who have uploaded their data, they've uploaded their profiles into the databases, and they share DNA with your unknown perpetrator or your victim. The matches are presented in the form of centimorgans, and a centimorgan is nothing more than just a genetic unit of measurement to describe how much DNA two people share with their relatives. The higher the number of centimorgans, the more DNA they share, meaning the closer related they are. There is a tool online, it's called the Shared Centimorgan Project. This is a screenshot of it, that allows you to go in and you can actually enter in the number of shared centimorgans that you're seeing on your match list, and it gives you an idea of how you may be related to the match, or how your suspect may be related to the match. So for example, let's just say we had a match and we were seeing 2,000 shared centimorgans. That means that we're likely looking at a grandparent, grandchild, an aunt, uncle, niece, nephew, or a sibling, half-sibling relationship. So this looks pretty good. This means if we would receive a match to our suspect in the 2,000 range, we're pretty close to being able to identify how those two individuals are actually related and who our suspect may be. By contrast, if we only receive 86 shared centimorgans, things look a lot more complicated. If that would mean that your match and your suspect, they are not nearly as closely related, and further, the way that they may be related, we have a lot more options. So in this scenario, this would require extensive tree building, and it would probably take a very, very long time if we were ever even able to really determine how our suspect may be related to this match. All right, so tree building, this is a very, very simplistic example of how this actually works, but that is one of the biggest questions that I get. So we're building out these family trees. How does building out a family tree actually help you zero in on any one particular person? So let's just consider in this example that we have two matches to our potential suspect, match one and match two. We know who they are. We know that they are in fact first cousins. So if you think about your first cousins, you share a set of grandparents, right? That would be the most recent common ancestor you would share with your first cousins. Because we know that these two matches are related as descendants of grandma and grandpa here in this illustration. And we know that both match 1 and match 2 are also related to our suspect. We can assume that our suspect is also a descendant from grandma and grandpa. So at that time, once we have identified the most recent common ancestor between two matches, we would want to build down that family tree. We want to add all their kids, their grandchildren, their great-grandchildren, and continue building it down, knowing that our suspect is likely within that branch of the family tree. Now, determining how far you have to build down, how you are able to zero in on one particular person, there are a lot of factors that can play into that. For example, if we have information from the investigation that tells us an estimated age of the suspect, right? That may give us some insight into a generation that we're looking at. So are we looking at a generational level of the grandchildren, or is this person likely younger, maybe at a great-grandchild level, right? Another big clue is looking at your match list and seeing how what the shared centimorgans look like. So let's just say in this example, based on our shared centimorgans, we also believe our suspect is a first cousin to match 1 and match 2. They share the right amount of centimorgans, and we think that they're all first cousins. We would want to build down grandma and grandpa's family tree to identify all of their grandchildren, so everybody in that first cousin level. And in our example, it's very easy. Grandma and grandpa only had one other grandchild. So this is the individual there circled in the middle that we would want to share with law enforcement and have them follow up on as a potential suspect. And again, I promise it is never this easy. It's a very simplistic example, but hopefully it helps just understand how we can get from a family tree down to zeroing in on just one, on an individual, or maybe even just a couple individuals. All right, so within the tree building process, there may come a time when we need to collect a reference test or a target test. These are DNA samples that are collected to either confirm or refute a theory developed during the tree building process. It's used to essentially narrow down the focus of the family tree. The individuals to be tested are typically identified by the genealogist, and these are used a lot to help overcome challenges such as endogamy, adoptions, misattributed paternity, situations where historical records, paper records are not taking us down the right path, where we really need an extra DNA sample to help confirm that we are on the right branch of the family tree. These are voluntary collections with informed consent. They are conducted and collected ideally by law enforcement after a pretty in-depth interview with the individual who is hopefully providing the sample. This is not the same thing as confirmation testing. We're going to talk about that in a second. But these samples, again, these are just meant to help narrow the focus of the tree. And as an example, let's think about a scenario in which we have identified our most recent common ancestor, okay? And based on all the information that we have, we think that our suspect is probably a great-grandchild of this couple. It sounds easy enough to build out the tree, right? We only have to build down a couple generations, identify the great-grandkids, and figure out which one of those great-grandkids could likely be our suspect. It sounds easy, but what happens when great-grandma and great-grandpa had 8 kids, and those 8 kids had a bunch of kids, and those kids had a bunch of kids? We are now down to this bottom line of all the great-grandkids, and our suspect could be any one of those. So what do we do with that? We could start, doing more traditional investigations into all of them, running timelines, figuring out where they were at the time of the crime. We could get DNA samples from a bunch of them. There are a lot of different things that we could do, or we could try a reference test to make our lives a lot easier. So I pulled out just a chunk of that family tree just to show how this could work. So this is our same scenario. We have our most recent common ancestor there up at the top. We think that our potential suspect is a great-grandchild. So what if we reference test this individual? We ask them to provide a DNA sample. We submit it to family tree DNA as an example, and we get the information back in our match list to show that this individual is related to our suspect. If that individual does not come back showing a grandparent-grandchild relationship, we know that we're not on the right track, right? Because in theory, if we are looking at that bottom line, we think that our potential suspect is a great-grandchild, then if we're testing that person who is circled above, we should see centimorgans that are consistent with the grandparent-grandchild relationship. And if we don't see that, we know we're not on the right branch of the family tree. So that helps us eliminate a whole side, and now we can focus on the right-hand side. So for reference testing, again, this is an exaggerated example. Most often when these are done, the individuals that are identified are so far removed from the suspect or the victim that once those individuals are identified, they don't even know each other. This is done when we're talking about going back many, many generations. We've got a large family tree and we're trying to narrow it down. For obvious reasons, law enforcement, I'm sure, would be hesitant to go out and talk to grandpa of our suspect and try to get a DNA sample, just for worrying about the integrity of the investigation. So this again is an exaggerated example, but hopefully it gives you an idea of how beneficial a reference test can be to help eliminate some of the possibilities. All right, very quickly, again, as we talked about earlier, the goal is to provide an investigative lead to law enforcement, right? So let's say we've zeroed in on a person, we have a potential name, we'd hand that over to law enforcement, and then it's time for more traditional police work. This is when we need to see if that individual really fits within the context of the crime, within the circumstances. Were they in the location? Did they know the victim? Like all of those things that we would try to be able to, or that we would work towards in making sure that the suspect fits. If law enforcement believes that they have their actual suspect, then we move on to the confirmation DNA testing. This quote was pulled directly from the interim policy. A suspect shall not be arrested based solely on a genetic association generated by a genetic genealogy service. So the genealogy work in itself is not enough for an arrest. This is why we have to do the confirmation DNA testing. And this is a direct comparison between the potential suspect's DNA and that forensic profile that's in CODIS. So remember I said we would come back to that. We talked about one of the requirements is that you have to have an STR profile already in CODIS searching without hitting to anything. And this is why. So now we have our potential suspect's DNA. Now we need to compare it to that forensic sample to make sure that we are actually placing our suspect at the crime scene, right? The potential suspect's DNA can be obtained different ways. It can be voluntary, but more often than not, we are seeing these collections done surreptitiously, and which will lead to Patty's discussion later on about the surreptitious collections and the considerations around abandoned DNA, the collection of abandoned DNA. Lastly, the one consideration with the confirmation DNA testing is that this is STR DNA analysis that is done by accredited laboratories. So your local, state, federal lab, whoever conducted the STR profile from the beginning is likely going to be the one doing this STR analysis on the suspect's sample and conducting that comparison for you. All right. Limitations, again, we mentioned that, this has been a game changer for law enforcement, but just be aware that there are limitations, and genealogy isn't something that you should just dive right into and think that it is going to solve every cold case that you have. It is costly. We talked about how we have to use private DNA vendors. It is time consuming. Depending on how closely your matches are related, it could take a very long time. I have been involved in cases that have been resolved within an hour of uploading to genealogy databases. I've also been involved in cases that have gone on for years and are still not resolved. So it can be very time consuming, and it's not going to lead to a resolution in every case. There are still limitations to the science. We touched on that a little bit, and there are limitations to the database or the databases. The databases are only as good as the information that's in them. Obviously, not everybody tests with these ancestry sites and not everybody opts in. So there are still limitations there. My key takeaways, I'm going to continue saying it, is that genealogy provides an investigative lead related to the identity of the unknown perpetrator. Arrest cannot be made solely based on the genealogy data. You have to follow, law enforcement must follow up and do that confirmation DNA testing. And there are the limitations. So we should never just jump to genealogy in lieu of a thorough traditional investigation. And with that, I will turn it over to Patty.
Great. Thank you so much, Ashley. That's really valuable information. And you and I have presented together before, but it's always great to hear this information and capture all of the insight from it. Really appreciate it. So as Ashley has been describing, we're looking into a relatively new area in terms of scientific innovation. We're talking about a combination of genetic analysis, but together with traditional historical and genealogical research. So it's not just about science, it's also about genealogy, and it's also about law enforcement investigation. Ashley's done an amazing job of discussing SNPs and how they can give us so much more information than traditional DNA testing. And the whole design behind what we're discussing is to generate an investigative lead. Now, all of us are aware anecdotally of so many different cases that we read about in the media, homicides as well as sexual assaults that have not been resolvable. There weren't any suspects who could be identified. There wasn't any hit generated from CODIS. Sometimes also VICAP was employed, and there wasn't data coming from VICAP that would be of assistance. So what we're really looking at is an innovation within science that really is designed to generate an investigative lead, and then the work continues on. Okay. I mentioned at the very beginning that collaboration is really at the heart of this work. In order to even qualify for forensic genetic genealogy, there has to be a showing of this kind of decision and this kind of collaborative decision making. Crime laboratory analysts are in the best possible positions to advise prosecutors and investigators about the quantity and quality of the extant DNA from the victim or from the crime scene. They know what it takes and can really help inform the collaboration. Investigators are certainly aware of the status of evidence within the investigation and the potential of any other leads that might lead to other evidence. And a prosecutor is able to put all of this information together to assist in the very important decision making of whether or not forensic genetic genealogy should be pursued. And it's really important to think about this also. It's really part of a case review, and case reviews are critical to the work of all of the actors in the criminal justice system. So talking just briefly about collaboration with the DNA analysts, what the prosecutor and law enforcement professional are going to do is to identify the sources of the DNA that are known to them from the investigation, but also in the context of the crime. Why is that evidence important? How does that evidence link a possible suspect with the victim or a suspect with the crime scene? So linkage among persons, but also in the context of the case and the crime scene is also going to be very important. And as I mentioned, the laboratory analyst is in the best possible position, knowing what the quantity and quality of that DNA evidence is, to really give appropriate advice as to what the possibilities are. There may have been prior testing, and there might have been testing limitations. There may have been a mixture with not an earlier ability to isolate a discrete donor profile. And we know now that thanks to the inroads that are being made in DNA technology, that is possible. And so really we can't even emphasize enough the importance of that aspect of the collaboration. So the work is going to look like this if we were to graph it out. First of all, we're dealing with a violent crime. We have what is believed to be a sample from a possible suspect, or as Ashley also mentioned, we can utilize this for unidentified human remains of a homicide victim. But we start with the violent crime and the possible suspect's DNA. We've already uploaded the evidence that we have into CODIS, and we do not have a match from CODIS. NamUs and VICAP may also be employed. And again, there is insufficient information from those sources to help advance the investigation. And so what law enforcement is going to do is to try to follow all reasonable investigatory leads to either resolve identity or perhaps to identify human remains. And it's only after all of these steps are undertaken that there's going to be a determination of potential forensic genetic genealogy. So you can really see what the process is and how important that collaboration is as well. Ashley has already reviewed this with you, but I really want to put this back in a prosecution and investigatory context as well. So the DNA is submitted from the perpetrator whose identity we don't know. The laboratory then is going to develop data that is compatible with the genealogical databases that Ashley has already described to you. Not all of them are going to be allowing this upload. So familial matches then might be generated between the unknown person and consumers who have specifically consented. And that's so important to the usage of the public databases. It's really based upon the premise that a person still maintains consent. And a lot of careful analysis is given that feature. With the assistance of genealogy, a person specialized in that area, there's going to be tree building to try to determine relationships, much like the branches on a tree, between the unknown person and the potential of any matches. And that work may be done by a genealogist, but also there may be input from law enforcement professionals as well, who are able to develop additional information through public records, through birth certificates, through death certificates, how old a person would have been, what area of the country they might be in, and really fleshing out the branches of the tree. And then finally, and ultimately, there's going to be an effort to get a confirmatory DNA sample so that there can be a comparison and then an upload into CODIS. So it's quite a process, but it really is an important one when you think about advancing justice for victims and for their families. So going back to case review, which is really an invaluable component of this work, there's going to be a briefing on the investigation and the evidence. What evidence is extant, especially in cold cases? What evidence has never been tested? What evidence should be tested that has not been tested? What's been the packaging employed for the extant DNA sample that we're concerned with? Can we establish the integrity of that sample? And at all times during this conversation, there's going to be attention given to identifying and discussing the evidence associated with linkage of the victim and the offender, or the offender and the crime scene. And that's critical to our ability to advance cases. So when we're reviewing these cases, we're really trying to develop insight from the evidence. Are we looking potentially at serial perpetration, or perhaps an offender may have committed other violent crimes as well? So we're really trying to keep this general perspective in our view at all times as well. We're looking for evidence that could corroborate a victim's disclosure or testimony, or we're looking for evidence that might suggest the presence or the involvement of the offender, or may negate the presence or the involvement of the offender. So we dive deeper into our analysis of these cases, and we're really focused on Are there new details that are significant, as well as the earlier information that might have been developed in a cold case investigation? And we're looking at physical evidence, forensic evidence, behavioral evidence, and testimonial evidence as well. It's important to remember the benefit of CODIS, which is the gold standard, as well as VICAP. These are really invaluable references to try to determine if there is linkage between an offender, a suspect, and potentially other victims or other crime scenes as well. Ashley's already spoken at length about the differences between FGG and familial searching, so I'm not going to go into additional detail there. But I really do want to mention that there are several states that have statutes that allow for familial searching. And in many of those states, there is a requirement that familial searching be employed before forensic genetic genealogy is pursued. So it's important to know that. And as Ashley did a great job of describing earlier, you can really see much closer relationships from forensic genetic genealogy. State versus Williams is a relatively recent case that addresses the issue of standing. And it's important to think potentially about all of the arguments that could be addressed in these cases. And in Williams, a DNA profile from spermatozoa was recovered from a victim. It was submitted for a familial DNA search, and the familial search resulted in two individuals being identified as possibly biologically related to the suspect in this case. The two individuals were Arthur Williams, who was later identified as the defendant's brother, and Michael Murray, who was Arthur Williams' son, and thus the defendant's nephew. So this was the association that was developed through a familial search. As the search that was conducted did not impact any privacy right of the defendant, the court found he did not have standing to invoke the exclusionary rule. He had sought to suppress the statements that he made and the DNA evidence that was obtained because of the investigative search using familial DNA. The court specifically noted that he cannot assert a personal privacy interest in his relatives' DNA profiles. So that's important to remember as well when we evaluate standing. I'm going to just quickly touch upon some search restrictions and guidance. One of them is from Maryland, and not every state has this, but I think it's really important for all of us to at least consider it because of the critical policy reasons that it really does emphasize. And this is from Maryland. The forensic genetic genealogy search may not be initiated without a judge's approval and without certifying before the court that the sample, the DNA sample, and the criminal case satisfy this criterion. And what the requirement is, there needs to be a sworn affidavit submitted by a law enforcement agent with the approval of a prosecutor. Again, we go to the spirit of collaboration that we've been discussing from the relevant jurisdiction. And this is what needs to be established, that the crime is a violent crime. In fact, they're talking about an attempt to commit murder, rape, a felony sexual offense, or a criminal act involving an ongoing threat to public safety or national security. So it has to be an extremely serious crime. The sample to be subjected to the forensic genetic genealogy search is biological material reasonably believed by investigators based upon their investigation and their deep knowledge of that investigation to have been deposited by a putative perpetrator, and the forensic sample was collected from a crime scene, a person, item, or location connected, linked to the criminal event, as we've been discussing, or the unidentified human remains of a suspected homicide victim. The requirements go on. An STR DNA profile has already been developed from the forensic sample, just as we've discussed earlier. It was entered into the statewide DNA database and the national DNA database, and has failed to identify a known offender, a known individual. And then finally, unless the crime being investigated represents an ongoing threat to public safety or national security, reasonable investigative leads have been pursued and failed to identify the perpetrator. So you can see how this really tracks the interim policy that Ashley described for you earlier through this particular statute in Maryland. Let's talk just for a moment about standing with the familial search. State of Washington versus Hartman is another case. In this case, investigators had made a warrantless comparison. They had obtained crime scene DNA, and they compared them to DNA profiles that the defendant's relatives had posted to a consumer DNA database. And this is a first-degree felony murder case based on the rape and murder of a 12-year-old victim. It's a cold case. It occurred over 30 years ago. The defendant alleged that the DNA comparison invaded his privacy in violation of the Washington State Constitution. So he moved to suppress evidence of the relative's DNA as well as evidence of his own DNA. And that's an interesting argument. We'll talk about that as a result of the evidence, and he moved to dismiss. The court denied the motion, and the defendant went on to try this case to the court in a bench trial, and he was convicted. The trial court ruled that he did not have standing to challenge the comparison of the DNA from the crime scene in the GEDmatch database because he didn't have a privacy interest in his cousin's DNA in the database. Makes sense. In addition, the relatives of the defendant had voluntarily uploaded their DNA into the database, and the DNA that the defendant had left at the crime scene was abandoned. It wasn't private. So you can really see the reasoning of the court in terms of standing and a privacy interest, and whether or not there is a privacy interest in DNA had by family members who voluntarily uploaded that into those companies. The court held that there's no privacy interest in commonly held DNA. Just like we've discussed, there's no privacy interest when somebody deposits or leaves behind their DNA at a crime scene. Absent a privacy interest, he didn't have standing to challenge that comparison. And it's interesting, the court goes on to note the legislature could adopt statutory restrictions, and the companies that run consumer DNA databases, and Ashley referred to this earlier, could adopt policies limiting law enforcement's access to this kind of genetic information in those databases without a warrant. In fact, GEDmatch did that in 2019 after this case occurred. So now you know kind of what's behind some of the areas that Ashley and I are discussing. As Ashley noted, we're talking about an investigatory lead. That's basically the great value of a forensic genetic genealogy lead. In that process, we're going to need to have DNA from the possible suspect that we're focusing on. So what we initially have is an investigatory lead. After all of the genealogy work is done, those associations have been built, the law enforcement investigation is ongoing. Now what we need is DNA from that person associated with the crime. It's important when we talk about collecting discarded DNA. That can be a very valuable effort because in that regard, the offender may remain unaware of the investigation. Law enforcement may be developing focus on the offender, but they may not know anything about it. And so if there is discarded DNA, that DNA, if lawfully taken, can give the crime laboratory a chance to test that DNA, to compare it with the extant DNA. And this is STR testing that's being done. So the value of collecting discarded DNA when it's done legally and appropriately, there is less of a chance of an offender becoming aware, less of a chance of possible evidence tampering, and certainly less of a chance of witness intimidation if there are still witnesses available. So when we talk about the confirmatory sample, as Ashley already noted, having the forensic genetic genealogy lead is not a basis for an arrest, but it is the lead comes about and helps to establish probable cause based upon the sufficiency of the genetic and the non-genetic information. In other words, the investigation and the corroboration of salient points linking the suspect to the crime. So law enforcement is going to want a confirmatory sample. There are different ways to get this. Collecting surreptitiously DNA or abandoned DNA are a couple of ways. It can be done by consent. It can also be done through a search warrant. We all know in terms of homicide investigations that someone may consent to the obtaining of DNA and later on try to void or take away that consent based upon a number of different arguments, that there was a misrepresentation, that it was not a knowing and voluntary act, and litigation may very well go on. In a search warrant, the probable cause is going to lay out in that affidavit the reasons, and a judge may approve that, which may give a stronger status, if you will, and surreptitious or abandoned DNA as well. The results of testing the confirmatory sample are going to be compared with the DNA from the victim or the crime scene, and that's the evidence that's going to be presented at trial. Remember, what led us to this point, the forensic genetic genealogy lead, was just a lead in that area. So let's take a look at some other areas that we want to consider. We're going to be really making major decisions in terms of how much information a law enforcement professional is going to include in their affidavit for a search warrant. We'll look at a couple of cases to give you some ideas about that. There's been reference to DNA testing, but not going into every different aspect of forensic genetic genealogy. There are cases out there that talk about putting this in terms of an informant or reliable information and not spelling out FGG. So we're going to be talking about some of those cases momentarily. What's really important, though, is that we really engage in an effort to protect the privacy of individuals within that genealogy search. Law enforcement may be speaking to relatives in an effort to get closer to where that suspect is, and those persons' names may appear in a law enforcement file. Every state has an equivalent to a Public Records Act. So we have to take a careful look at the statutes in your jurisdiction to determine if there are protective orders available to protect the identity of those individuals and to engage in that kind of statutory remedy if possible. We want to also make sure that we are appropriately engaging in surreptitiously obtained DNA. We need to know what the law is. We need to be very clear on whether or not the DNA is abandoned and really document that in terms of the investigation. And then finally, we're going to be looking toward establishing that probable cause with the genetic information and the investigatory lead. California versus Greenwood, a U.S. Supreme Court case, is really the lead case in this area. And every state has their own rules and their own interpretations of the right to privacy in their statutes that are, for the most part, consistent within the ambit of California Greenwood, but there might be some differences in different jurisdictions. The Fourth Amendment doesn't prohibit a warrantless search and a seizure of garbage that's left outside for collection, outside the curtilage of the home. Now, for those of us on this call that are prosecutors, doesn't that take you back to law school? All of the cases that talked about curtilage and how important it was to determine what area was within a curtilage. This kind of search would violate the Fourth Amendment only if the persons involved manifested subjective expectation of privacy in their garbage that society in general would view as objectively reasonable. But the court goes on to say that individual states are free to construe their own constitutions, imposing more reasonable restraints, more stringent restraints on police conduct than the federal Constitution does. That's why it's so important to be really conversant with case law in your jurisdiction. So these are some of the legal considerations following California versus Greenwood. Uh, An investigator should carefully document any associated surveillance, including offender conduct and context when DNA is discarded. We really want to be able to establish that this was knowingly done and that there was no subjective belief that privacy was involved. So this is something for us to be very careful about. There are some very interesting cases here. I'm not going to go into all of them. I wanted to mention just a few for you. The Perkins case, Massachusetts case from 2008 was a murder case. The defendant is in custody. He's provided with his Miranda rights. He smoked 2 cigarettes and drank a can of soda. And then after the interview, he left. Well, the cigarette butts and the soda can were retrieved by law enforcement. The argument was made that he couldn't take them with him. He was in custody. So what could he do but leave them? But he wasn't surrendering a privacy interest. And law enforcement basically said, well, they waited about 20 minutes and there was no rule about him not being able to come back and pick up that property. So that property was able to be used for DNA purposes. Hudson versus Texas is another case that's interesting. The defendant in this case is actually in custody on another case. He's advised of his Miranda warnings. He had asked for a Dr. Pepper to drink during that interview. It was given to him. Toward the end of the interview, he took the can and smashed it up against a trash can, and he left. And the court again denied that motion to suppress and said that clearly there was an intent to abandon that property. Finally, I just want to touch upon State versus Reed, which is a very interesting case, and it takes us back to curtilage. In this particular case, law enforcement went on the premises of the suspect to have a conversation with them. They're back in the patio area of that home, and the suspect was smoking a cigarette, finished smoking the cigarette, basically took the cigarette butt apart, took the cover off of it, ground it up, and placed it in his pocket, and then made some kind of reference to watching CSI, the show that's been on television. He goes on to light another cigarette, and after he finishes that cigarette during the conversation, he flicks the butt and puts it over toward some trash that was in the corner of the cement patio. Law enforcement rolled that over to an area outside of the patio, and the court very clearly said that this could not be done, that he had a privacy interest in that curtilage of the patio, and a new trial was ordered. So take a look at the cases in your area, some very interesting cases in the area of discarded DNA. So I want to talk just for a couple of minutes on presenting evidence following the FGG lead in terms of affidavits, pretrial, and trial considerations. In Corbett versus State, the detective reported that he received an investigative lead regarding unknown male DNA, and that this led to identification of a suspect, Mr. Corbett. The court agreed with both parties, and this is interesting language because it's been picked up by law enforcement and prosecutors and some other jurisdictions. The investigative lead resulting from FGG was essentially an anonymous tip. Now, think about your acquaintance with anonymous tip. In drug cases, there's got to be corroboration, there's got to be reliability. And the court did point to precedent in another case, said that an anonymous tip alone is insufficient to establish reasonable suspicion, but it can be corroborated and you can establish a reasonable suspicion that way. And so in this particular case, the detective goes on to detail that investigation and how it led to identification of the suspect with a compatible description of the attacker and the closeness of the suspect who lived less than a mile from the victim's home. There was then a knock and talk that was conducted to make sure that the suspect was living at the house. A trash pull was conducted, and the court goes on to state that this corroboration supported a finding of reasonable suspicion. That's how it was handled in this particular case. Now, with this affidavit, it contained not only the hearsay evidence talking about the identification of the suspect as an investigatory lead, but also other evidence that established it, and the court felt that there was sufficient probable cause. So if you're looking at it from this particular viewpoint, that corroboration and reliability is absolutely critical to establish the reliability of an investigatory lead. Bortree is an unpublished case. I want to make sure that we all know that. And the reason that we included this case is that in this particular case, there was a lot of attention given to forensic genetic genealogy. In fact, it was really spelled out when you have an opportunity to look at this case. There's a great amount of detail that's provided throughout. The affidavit for the search warrant was about half as long as the affidavit in support of the search warrant for the home of the offender, and the court found that the affidavits were valid. They were readily sufficient for a neutral and detached magistrate to find probable cause to issue the search warrants. So Bortree had argued before the trial court that there was error because the court didn't exclude trial testimony and evidence related to the work conducted by the FGG company. Now, it's interesting. This is a case where all of this information was brought out, and it's not necessarily requisite because this is an investigatory lead. It's not the end of the story by any means. But in this particular case, the court found the evidence didn't establish any illegal activity by engaging in the FGG research. In fact, and this is something that we've been really emphasizing in our time together, it did not yield any substantive evidence that Bortree had engaged in any criminal activity. It merely narrowed the focus of law enforcement. And this is primarily the argument of investigators and prosecutors through the cases that we've been discussing. This case was reversed on other grounds not having to do with FGG. It was reversed and remanded. So what we're doing, we want to really put together the extent of information to support how we are able to identify the suspect. What you can do in terms of references in an affidavit, consider a reference to DNA testing that was employed. There may not be a need to provide any additional information because it's only a lead. Then detail the investigative efforts that followed that lead, how the suspect was identified, surveillance, if there was surreptitious DNA. And this would be the evidence provided to the court and ultimately to a jury. And so what we want to make sure in working with investigators is that the investigator is familiar with any rulings regarding the admissibility and that any particular language should be utilized. An investigatory lead really is one of those. An investigator may testify to developing a lead and what that lead led to and what work was done. I think it's important also that we take a look at CODIS hit cases to be familiar with restrictions, and many jurisdictions have them. We're not able to say that there is a match, or in many jurisdictions cannot refer to CODIS. And that might give you even additional guidance in terms of determining how this evidence is going to be presented. And this is really important too, detailing that search for the suspect based upon the investigative lead. We're going to be talking about corroborating the age of the offender, the geographic presence, and other crime-related considerations that might be important. So what the investigator is going to testify is to the chronology of the investigation over the years, from the cold case, the work that was done earlier, to the work that was done after a lead was developed. And this may include efforts to identify suspects over a period of years. It may take us into looking at the autopsy finding, witness interviews. There may have been vehicle license checks that were done. There's going to be voluminous evidence, even of earlier efforts, as well as the follow-up. We're going to provide information about previous evidentiary submissions, if that's appropriate or relevant in the jurisdiction, and really explain to the court and to the jury how all leads actually were exhausted. When contact is made with the suspect, we're going to provide ample information about that, what information was provided to the suspect, if there was a custodial interrogation, were the Miranda rights given, what questions were asked, and what answers were given. It's interesting, there may be many cases where if a suspect is not aware that there is a hit, there's DNA, they may not recognize a person. And then later on, when that information becomes available, there may actually be a consent defense. We've seen this in some cases. So these are just a few considerations when you have the opportunity to review them. We want to take a look at the suspect's earlier denials, which, as I said, could change after testing of untested sexual assault evidence. Be aware of the timelines and other events that may have occurred. This may be a very recent alibi that earlier was not raised, and we need to look into the context to understand why that may be. So the investigator is also going to talk about the collecting of DNA from the evidence. Was this done through consent, through a search warrant? We want to make sure that the chain of custody with that evidence is clearly established with reference to the evidentiary packaging, the date, the time, the initialing, and all at every point along the way, how the integrity of that evidence was maintained. What was the storage? If this is a cold case, was it moved between crime labs? And very carefully, we're going to track that evidence over a period of time. So this is something that we need to really be on top of. The laboratory analyst on the witness stand is going to talk about the evidence presented for their analysis, the STR testing that was used, a description of that process, peer review, and what the results are. And then there will be testimony to the findings and the statistical representation of that particular profile that was developed in a given population. So this is just simply an overview of trial with DNA. We know it to be an eloquent witness that can help establish that critical connection as well as accountability when the evidence indicates that beyond reasonable doubt. During jury selection, we're going to carefully explore any cold case issues that we have, and we're going to build the case with DNA, emphasizing at all times the significance of that linkage. And if we have an FGG lead, the importance of that lead, always ensuring that the evidence is understandable to a jury. So going forward, we want to advance cases without CODIS hits or investigative leads to forensic genetic genealogy when that's appropriate, given all of the evidence and the collaboration that we're engaged in. We want to proactively address issues regarding the seizure of abandoned DNA. We want to get there first and make sure that it is well done, pursuant to the law, it's documented, and we're able to defend it. And then finally, taking a look at case law within your jurisdiction as well as others, we want to prepare a summary of evidence of that investigatory lead when we engage in putting together or assisting law enforcement in that affidavit for the search warrant and for use in litigation.